Welcome to the 29th meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent their mobile phones and other electronic devices. And we have received apologies from Katie Clark, MSP. The first item of business is to decide whether to take items 6, 7, 8, 9, 10, 11, 12, 13, 14 and 15 in private. Is the committee content to take these items in private?
Yes.
Under agenda item number 2, we're considering an instrument subject to the affirmative procedure. No issues have been raised on the draft Sexual Offences Act 2003 Notification Requirements Scotland Amendment Regulations 2025. Is the committee content with this instrument?
Yeah.
Under agenda item number 3, we're considering instruments subject to the negative procedure. An issue has been raised on SSI 2025-280. The National Health Service Charges to Overseas Visitors Scotland Amendment Regulations 2025. The instrument creates exemptions from NHS charges for people who come to the UK for medical treatment under the Gaza Medical Evacuation Scheme and people authorised to accompany them if the need for treatment arose during the visit. This instrument falls to be reported to the Parliament under Reporting Ground J for a failure to lay the instrument in accordance with Section 28(2) of the Interpretation and Legislative Reform Scotland Act 2010. The instrument was laid on the 7th of October 2025 and came into force on the next day, breaching the 28-day rule in the 2010 Act, which requires that a negative instrument must be laid before the Scottish Parliament at least 28 days before it comes into force. The Scottish Government is required by the 2010 Act to explain to the presiding officer why the lane requirements have not been complied with. The Scottish Government explained in its letter dated the 7th of October that the instrument was being brought into force the next day in order to provide clarity to those who are responsible for making and recovering charges from overseas visitors and to provide assurance to those in Scotland under the Gaza medical evacuation operation that no children under the operation for their accompanying persons will be charged for NHS services. Does the committee wish to draw this instrument to the attention of the Parliament under Reporting Ground J for failure to comply with lane requirements as it was not laid 28 counting days before it comes into force? And is the committee content with the reasons provided for the failure to comply with the laying requirements? No issues have been raised on SSI 2025-278. Is the committee content with this instrument? Under agenda item number 4, we're considering a document laid for consultation. No issues have been raised on SG 2025-238, the proposed draft order, Public Services Reform, Scottish Water Order 2026. Is the committee content with this instrument? Oh, sorry, is the committee content with this proposed draft order?
Yes.
Okay, thank you. Okay, with that, I'll briefly suspend the session. Under agenda item number 5, we are taking evidence from Graham Day MSP, the Minister for Parliamentary Business, and this is one of our regular sessions with the Minister on the Scottish Government's work relevant to the committee. And Minister, welcome back to your role and also welcome back to the committee. The Minister is accompanied by 3 Scottish Government officials: Stephen McGregor, the Head of Parliament and Legislation Unit, and Claire Trail, SSI and UK Legislation Team Leader, and Douglas Kerr, the Deputy Legislation Coordinator in the Scottish Government Legal Directorate. I welcome you all to the meeting. Just want to remind everyone, obviously, just don't worry about the microphones, because they'll obviously come on automatically. They're controlled by broadcasting. Minister, I'd like to invite you to have any opening remarks.
Thanks, Camille. Good morning, everyone. And thank you for inviting me to join you to discuss the matters within the committee's remit. I'm grateful to the committee for their work in considering around 100 SSIs since my predecessor's appearance before you on the 1st of April. And I was encouraged in taking on this role to note that there were fewer instruments in 24-25 with issues, in particular serious issues, than in the previous year. However, it would be remiss of me not to acknowledge that there has been some increase in issues in SSIs in the first quarter of this year, which I'm sure we'll cover in due course. While this is partly explained by a package of pension SSIs, I want to reassure the committee at the outset that the Scottish Government is carefully considering what it can do to ensure that this does not become a trend and that we maintain our otherwise good record. In addition to secondary legislation, I would highlight that we've introduced 7 bills since the 1st of April. And to conclude, I want to thank you for the diligence with which you consider the legislation that comes before you, and I'm grateful for the close working relationship between our officials. The role of the DPLR committee is hugely important in terms of the operation of this Parliament, as I know from my previous time in the role. Together with Douglas Kerr, Stephen McGregor and Claire Trill, I'm happy to answer any questions that the committee has, and if required, we'll also follow up in writing. But given I've only been in post or back in post for a few weeks, and I'm still getting fully up to speed on all of this, I will, with your indulgence, Convener, lean on the officials for detail so we can provide answers which fully meet your aspirations today.
Okay, no, thank you very much for that, Minister, and I fully appreciate the point there regarding the details, so I'm relaxed about that. I think so. You did touch upon, Minister, regarding the first quarter, the report that our committee published, and yeah, I think just certainly for the record, the committee has identified a lot more issues in SSIs in recent months, with 28% of the instruments considered between the 13th of May and 8th of September being reported. One of the kind of key things, certainly for us as a committee, was that in just 6 of the reported instruments, the committee found 30 individual issues, including some quite serious issues around potentially defective drafting. So notwithstanding the comments that you have just touched upon, Minister, are you concerned by this upturn in the issues that have been identified?
I'm concerned that this occurred. I think it would be wrong of me to say otherwise. When I first came back into post within a few days and this was brought to my attention, my question to officials and to the lawyers was, how could that have happened? I'm going to bring Douglas in a moment, if I may, Convener, to give you a bit of background to how it came about. But I don't in any way want to be seen to be making excuses today for what occurred. It's a matter we take seriously. Clearly, a sizable proportion of the errors pertain to a particular set of regs, pensions related, which is a very complex area. But there was another set of another area similarly complex involving an evolving policy change situation. And that has prompted us to go away and look at what more we need to do. And I'll come to that in a moment. But if it would be useful to you, I'll ask Douglas to provide an explanation of the background to what occurred.
Thanks, Minister. Yes, on the pensions exercise, first I'll say that in general, as the Minister said, obviously we kind of regret these figures. It's not where we want to be, and we do kind of strive to get things right first time. And when we do make errors, we reflect, we try to identify why those have occurred and see what we can do to stop that happening again. On the pensions exercise, I would just say that these are a lot of areas of law can be technical and complex, but I think pensions legislation is particularly complex and technical. This package of pension exercise was responding to the McLeod remedy, which was being implemented to respond to a court judgment. It was quite not everything is. I'm hesitant to say that everything's complex, but it was complex to implement that judgment. The reserve devolved mix, there's a bit of interplay there because the policy is kind of owned by the UK government, but ministers have some executive competence to make pensions exercise and implement them. So there was a degree of needing to kind of keep pace and see what was happening with the policy changes. And these pension SSIs were correcting previous SSIs, and there was a gap in between those. That was partly because, as part of the implementation of the McLeod remedy, there was a need to make wider changes to the SSIs and SIs in Wales to learn from how it was being implemented over time, and so there was wider policy changes being made alongside fixing the corrections from the previous SSIs, and I think all of that kind of in the mix meant that some sight was lost of the previous commitments to make corrections. We've, as I said, reflected on what happened with those. In general, we've circulated the committee's report. We've highlighted the particular concern the committee expressed in the report, and the fact that the convener made the statement of Parliament to highlight the report. That's been circulated to all of our teams to make them aware of this and to kind of implore upon them the need to do everything we can to minimise errors. We have also looked at the particular issue here of when we are meeting commitments to correct SSIs in correcting errors in previous SSIs. We have made a kind of slight change to our quality assurance processes. We're now requiring drafters to provide additional information to the people conducting the checks, and that is to ensure that they have the kind of full history and context of the instruments, and that will hopefully provide additional material which will aid in preventing these type of errors occurring again. And then lastly, we're looking at what further training in general we can provide on SI checking, but also just drafting more broadly to see what we can do to minimise this reoccurring.
Okay, I think that's helpful. I'll pick up on just one of the points at this section, and that's just regarding the technical nature. I don't doubt that in any way, shape, but I'm sure, I think we would all recognise that the vast majority of legislation will be technical in nature anyway. So I'm probably not fully supportive of that element of the technical nature, to be quite honest. You did touch upon there regarding the additional information to be provided to drafters. Can you elaborate a bit more on that, please? Because I know certainly in the past our committee we have tried to have an improved understanding as to the process that does take place when SSIs have been drafted. And I know certainly, I think it was 2 or 3 years ago, I think there were some changes were put in place at that point. So we're just kind of keen to flesh out a bit more in terms of where we are with that.
So as we've explained in the past, when SSIs are kind of submitted for their checks at different levels, there are kind of official lines and kind of guidance where the drafter was to provide the SSI, any relevant enabling powers and kind of information about the instrument. We've added to our kind of formal requirements on that to say that any previous correspondence with the committee, so that would be the question and answers, the DPRC's report on the instrument, so that we can see exactly what the committee said and what you were looking for from our commitment, and any additional context the drafter can provide to the person doing the check, so that it can pinpoint this provision is meeting this commitment, and that's with a view to just making that specifically clear for the person doing the check. It could be, and I would expect to see that in the past, some drafters might have done that as a matter of course, but we've now made that a kind of official part of what we're asking them to do. And in terms of keeping track of the commitments, we've also kind of refreshed, but we have always captured the commitments and kept a log of them, but we've refreshed that just to present the information in a clearer way, so that information is much more clearly at our fingertips, so that it enables a bit more kind of active and better monitoring of that.
Minister?
I think the other thing to say, Convener, is that there is an additional level of checking, which is a fresh pair of eyes, which I think we would all agree is a useful exercise, because I think to your point about all legislation is technical, you're right, but sometimes it's very complex as well, which was the case in the pension regs. And that's why it's important that you get a fresh pair of eyes looking at this at some stage in the process, because I think at some point in this, you're seeing what you think you see in front of you. So an experienced pair of fresh eyes looking at it. I should also expand on Douglas's point around additional training. We are actively looking at a very specific SI-related training stream that we can make available to colleagues, because we do absolutely take seriously the concerns that the committee has raised in this instance.
Okay, I think so. Just on that point, has there been much of a staff turnover within the department, or has the staff remained fairly stable over certainly this quarter and before?
I think it's remained fairly stable. I think we have recently taken on some new lawyers, but I think I think that's been more recent than the last the quarter one. The kind of pool of stylists that kind of check the kind of final conduct that final review of an SSI has remained fairly stable. As time goes on, one or two individuals might leave the group, one or two might join, but on the whole, it's remained fairly stable, I'd say.
Okay. Would it be possible to send over this kind of updated process that you have to the committee?
Yeah, absolutely.
Okay, well, I think that'd be helpful. Thank you. I think certainly just on the point you raised, Minister, regarding the kind of SI training, I think it'd be useful just if the committee could get sight of kind of what that's going to entail as well, please.
Where it would give additionality what's already in place. Well, we can happily write to you on that. I just want to get across the point, Convener, that this is a matter we take extremely seriously, and I expect to see our performance improve on that first quarter.
Right, okay, well, that's helpful, thank you. So just kind of on a related matter, so certainly there was an unusual issue that did arise in recent months of amending instruments, which actually didn't address all the issues which the Scottish Government undertook to correct, and indeed which actually introduced some further problems. So just in terms of the processes and checking, so you've already just touched upon this with regards to kind of the overarching. Would that also include this type of situation where something's already came to the committee, we have highlighted, it then goes back to the government to look at again, or would that be kind of a separate process?
Okay, I'll bring Stephen in or Claire in on this. Douglas, sorry, I'll bring Douglas in.
Yes, so the additional information that we're asking drafters to give to the people conducting the checks about the previous TPRC correspondence and reports, that's specifically to address that situation.
Right. Okay. Okay. No, thank you. Anyone else want to comment on that before we move on? Okay. Okay, thank you. I'm going to bring in Ros McCall.
Thank you. And hello, Minister. Welcome back. Excuse me if I'm squinting a little. Unfortunately, you're silhouetted just at my angle. It's okay, but just bear with me if I'm squinting a little. The Net Zero Energy and Transport Committee recently raised concerns with the policy note for vehicle emissions trading scheme, Amendment Order 2025. There were concerns it was written with assumed knowledge of technical matters. So that was the point that they were raising. So are you and your officials, what are you doing to ensure that policy notes are accessible, particularly to lay people, stakeholders and members like ourselves who are scrutinising the instruments?
I'll bring one of the officials in to give you the detail of that, but at a general point, I absolutely get that. When I was last in post, we introduced a cover note for SSIs that explained on one side of A4 what regs will actually set out to do, because they are very technical. Very often they're written in lawyer speak. It is not always easy for the lay person to understand that, and I think that point about assumed knowledge is a very good one. It predates my time. I wasn't alive to that, but I'll bring in the officials on this because I think it's really important. Claire.
Thank you. So I think it links slightly to what the comments my colleague Douglas mentioned in terms of that quality assurance process, that fresh pair of eyes looking through things, not just from a legal perspective, but that plain English. In terms of the guidance and support we offer policy officials in preparing that, we have a central SSI guidance that we continuously review in a similar way to the lawyers, looking at what are the common issues that are arising through committee scrutiny that officials need to be more mindful of in preparing SSIs. And we've also recently introduced a concept of a monthly drop-in session for policy officials who are working on SSIs to share their experience, to ask questions of one another and of us to be able to communicate points back to them on issues that are live and arising in Parliament right now.
That's interesting. So is this, as you say, it's recently? How recent, and is it well attended?
The session started over the summer. We just brought it in, and it's been a new team within a Parliament Legislation Unit, in continuing our own sort of learning within the team as well. An initiative we brought up, and it's been well attended, and we've done it for a good few months now, and it's going well.
Okay, no, that's great. Thank you, Convener.
Can I just add, Convener, that Ros McCall's contributions made me think that we need to reflect on this with a view to the next Parliament, because there will be a substantial intake of brand new MSPs who won't have even the 4 years knowledge that MSPs currently have. And it is difficult when you're first an MSP trying to get to grips with this. So I'll take that away and reflect on what we need to do to try and ensure that new intake in particular are able to hit the ground running. And I'd be interested in the committee's views if you want to write to me on the back of this session with any thoughts about how we could do that.
That's excellent. Thank you.
And Jeremy Balfour.
Yeah, good morning, Minister, and to your officials. Your officials provide us with subject committees with helpful weekly updates of instruments expected to be laid in the following 2 weeks. I wonder if you can maybe give some indication, or your officials can give some indication of anticipated volume of SSIs likely to be laid between now and the end of this session, and are there particular lead committees which are going to have more than others?
Okay, so as of right now, that we're anticipating circa 151 SSIs and 4 dual Parliament SIs to be laid before Parliament dissolves. But I should add that we're currently going through an additional triaging process around several others, so that number will rise. That is, I think, positively comparable with this point in previous sessions. By way of example, in session 5, there were 259 SIs that were laid in that period. If you want the breakdown, if that's helpful, Mr Balfour, there will be 53 affirmatives, 2 made affirmatives, 5 super affirmatives, 77 negative, and 18 laid with no procedure. In terms of managing workload, because I think that's what you're getting at, and we're very acutely aware of that. The officials work closely with the clerks of the committees. We do scan ahead to see what the workload is going to be, but you'll appreciate, as an experienced committee member yourself, that sometimes committees take on additional work at short notice, so that complicates things. The breakdown for committee by committee at the moment, from that 151, we expect local government, housing and planning to receive 24 instruments, health, social care and sport 23, criminal justice 20, net zero energy and transport 17, finance and public administration committee will have 12, rural affairs and islands would get 12, social justice and social security 10, the remainder would have 8 or fewer.
I mean, that's really helpful. I mean, obviously, I mean, maybe one of the differences this session is the number of bills that are also outstanding might need to get through before disillusionment. Again, what work are your officials doing with the Parliament clerks just to make sure that particularly those committees that have quite a number of bills at stage 2 or stage 1 also have time to give proper scrutiny to the SSIs?
Okay, I'll bring officials in to respond to that in the detail in terms of the engagement, but as a general point, it always feels like this at this stage in a Parliament, but actually the volume of bills, particularly government bills, is no higher than it has been previously. I think the volume of members' bills is maybe slightly higher, but it's fairly comparable. One of the complicating factors we've seen in this Parliament, as experienced colleagues around the room may recognise, is that committees have been taking longer at the stage 2 process. There's been additional sessions. Some of the stage 3s, as we will see this week, have been taking longer, and that's increased the sense of the pressure's greater than it has been. In strict number terms, it's not, but we are alive to the demands that some of the committees are facing. I'll maybe bring in Stephen or Claire to talk to that engagement that happens.
Yes, so we do plan ahead. We do try and avoid in the final year of the Parliament introducing a large legislative programme, which is why the year 5 programmes, we call it smaller than normal. We do try and avoid introducing bills to committees which are already busy. There's extensive engagement going on at the moment between us and parliamentary officials about the sequencing and scheduling of stage 1, stage 2 and stage 3, because we do realise there's not that many parliamentary days left, so it is a key piece of work for us at the moment.
Okay, again, that's helpful. And it's interesting, I think, to put on that record, because I think there is a feeling amongst some MSPs that the workload is perhaps more than had been in previous sessions, so that's quite helpful to have. Obviously, SSIs come in different shapes and sizes and require different types of scrutiny. Again, just looking up coming forward, are there any particular SSIs that you expect could require more scrutiny, more work from committees, or are they all roughly the same size and complexity?
So there's nothing in terms of the 289-page environmental amendment regs that you will all recall, but there are two specifically large SSIs due to be weighed, one on November the 24th, which is around 90 pages, another at the beginning of December, which is around 84 pages. So those are the two significantly large ones that we're anticipating, unless the officials think there's anything else we should bring to your attention.
Not anything additional, and I suppose it's just to note that we have, on the back of those particularly large SSIs last year, committed to and are engaging with the clerks and letting them know ahead of time when large instruments are coming forward, and also looking at limiting the overall volume of SSIs that are laid in Parliament when large instruments are coming forward.
Okay, thank you.
I should say there's perhaps another two to come into the new year, but in the immediate future, those are the two large ones.
Okay. Minister, you can put yourself into the history books if you can actually not only answer this question, but deal with it. And that is in relation to the SSI that you will have had on your desk previously in regard to the update of the Amendment of the Scotland Act 1998, Order 2019 SSI 219-193. As you appreciate from the time here, Noah came out of the ark before this was dealt with. What engagement have you had with, not when I say you, but your predecessors and officials had with the UK government about finding a solution? And do we have to admit we're never going to find a solution and this is just going to lie there? Or is there any possibility that we could deal with this within this particular Parliament?
I did recognise the description of that because it fell in my previous tenure as Parliamentary Business Minister. Look, I'm just as keen as anyone to see this dealt with. And I recall a commitment I made in 2019 in my previous time. My understanding currently is that following the session in April, the Cabinet Secretary for Rural Affairs, Land Reform and Islands provided a letter to the convener outlining the situation and next steps with regard to the Section 93 Scotland Act order that will correct the previous order. At that time, some complexities relating to interactions with another proposed instrument is still to be resolved. However, I'm pleased to advise, hot off the press, that these issues have since been resolved, allowing the process to move forward from that sticking point, and I can confirm to the committee that since then, official level agreement has been reached for this order, and that the Cabinet Secretary for Rural Affairs, Land Reform and Islands sent a letter to the UK Government just this week seeking, in principle, ministerial agreement to make the order.
That's helpful. As someone who's maybe not absolutely a favour of time scales for this, is it possible to, I'm not asking you to commit to it in any way, but is it possible that this could be resolved before the end of March?
Well, clearly, it will be dependent on the response we get from the UK Government to the Cabinet Secretary's letter, and I'm not trying to blame the UK Government for any delay, but in terms of the officials can perhaps give you an idea of the kind of timescales we would work to in these circumstances. So
we have certainly added the voice of this committee to the urgency of having this order delivered, and the officials that we're working with at the UK Government on this are very much aware of that. We have been able to, as the Minister said, secure official level agreement to the content of the order. With the exchange of ministerial letters pending, we should have a timetable in place to do that, and they're very aware of our preferred timetable for having this dealt with as quickly as possible. So theoretically, it should be doable. at this point.
We'll undertake to write to the committee and update you once we have that timetable.
I was going to ask that. That'd be very kind. Thank you, Minister.
Thank you. And Ross McCall.
Thank you very much indeed. Yeah, again, I do like to sort of look at a committee level, but onto bills. The Children Care Experience and Service Planning Scotland Bill was missed from the Scottish Government Delegated Powers Memorandum. What steps can you reassure us today are making sure that that sort of doesn't happen in the future and make sure that that issue doesn't happen?
Okay, I'll ask the officials to talk to the process that we would put in place to address that.
So I missed that.
Sorry, yeah, the Commencement Power in the Children Care Experience and Service Planning Scotland Bill was missed from the Scottish Government's Delegated Powers Memorandum.
Sorry, I understand now. I'd missed the,
Yep.
it was a specific commencement. I mean, we would expect all powers to be included. We would expect them to be explained and justified. So if something has been missed, then we will take that away and look at it. I mean, there's extensive guidance and process around this already. That's not the sort of thing that should be happening. So we'll take that one away and have a look.
Wonderful. And if any update as to how we can make sure that that would be great. And
Yeah.
no more on that. Minister, you've already highlighted how busy it is in committee stages. But what we are noticing is that, particularly when it comes to delegated powers, that there are more altered bills at stage 2. And this committee needs sufficient time to consider the delegated powers and the reports on those changes before it goes to stage 3. What reassurances can you give us on that so that we can get adequate time to scrutinise since there's been an upturn in SSIs on stage 2?
Look, I absolutely agree that about the crucial role that there is for committees in scrutinising delegated powers and bill. And since April, the government has consistently provided more than the minimum time required between bill stages, including the voluntary 14-day gap between stage 2 and stage 3, which exceeds the standing orders by 4 days. So we're trying to do everything we can to support thorough scrutiny. But I understand the frustrations that sometimes committees feel, given their other workload and how they can find time to get around to that.
Yeah, so can you give us any commitment to raising this concern with relevant individuals, ministerial and civil servants, just to ensure that though that thought is given to the timings between stages 2 and 3, given what you've just said?
Well, the timings between stages 2 and 3 are agreed in conjunction with Parliament. Having said earlier that we're not facing an overly congested legislative landscape between now and then compared to other years, it is busy. There's no doubt about that. And the scheduling of legislation, stages 2 and 3, is challenging at times. So I can't sit today and say that there's a magic wand I can wave here that's going to resolve this. But we do work in conjunction with committees to deadlines. They will suggest to us deadlines that they would like. We will try to accommodate that or as close to that as we possibly can. I can just assure you, as I say, that there is a lot of work goes into that. But I don't think I could sit here today and give you an assurance that we can magically improve the situation overnight.
Okay, well, much I appreciate that, but any relevant conversations even back with ministerial and civil servants just to highlight how important this is, knowing that we are in this, as you say, congested legislative landscape.
So one of the things that I will be doing in the next few weeks, I'd have started to do it by now, but for the fact that we're spending a lot of time in the chamber doing stage 3s currently, is to meet with each of the individual conveners to hear any concerns that they have. I recall in my last time in this role, towards the end of that Parliament, I worked very closely with a Conservative convener on one of the committees to reorder some of the work that they had coming to them, because he felt that would allow them to complete their programme, and we did that successfully. So where I can work with my officials to accommodate asks from committee, I'll give you the assurance that we'll look to do that to try and help manage their workloads.
That's excellent. Thank you. Thank you, Minister. Thank you, Convener.
Thank you. And Bill Kidd.
Thank you very much, Convener. Thanks, Minister and team. we note, of course, that the timing of LCMs not entirely within the Scottish Government's gift. However, the impact of some of the very short timescales in the committee's scrutiny have been noted as well. And standing orders have had to be suspended in relation to committees and lead committees' roles for the Bus Services No. 2 Bill and the Public Authorities Fraud, Error and Recovery Bill. So can I ask what updates the Minister can provide on discussions the Scottish Government has had with the UK Government about powers to make UK secondary legislation when it comes within devolved competence, and in particular, what arrangements have been considered for notifying Parliament about that secondary legislation, please?
Okay. I'll ask the officials to come in some of the detail that you're asking to, but as a general point, Mr Kidd, some of the issues which we've had, and I absolutely understand the frustration of Parliament around this, are actually the result of an improved relationship with the UK Government, whereby concerns that have been raised by the Scottish Government, the Scottish Parliament, or proposals have led to amendments in bills. And that in itself has created issues around the LCM process. So I'm not trying to make excuses or to defend this, but in some ways it's the consequence of improved working. But of course we want this to be better. I would much rather see LCMs going to committee rather than straight to the chamber. This committee should, in particular, should have that opportunity. But as to the direct conversations that have been taking place, perhaps the officials can expand on that.
So on the timetabling of LCM's point in your question, that's something that we regularly reiterate through our engagement with counterparts about the need to allow full opportunity for a Scottish Parliament to consider an LCM and a motion. Keeping in mind parliamentary recess dates are different, and most notably right now we're looking ahead to the election and what that means for the timetabling of UK bills that require the consent of this Parliament before and or after the election. On the engagement on UK SIs, we similarly work closely with them on identifying forthcoming SIs to understand the volumes and the nature, and we push to get a most complete picture as possible. Those conversations about engaging the Scottish Parliament in its role, most notably in the context of rule and EU exit, EU reset, and we continue those conversations to get as much possible information for us and also for the Scottish Parliament.
Okay, thank you. Well, recognising, as we've been talking about, the timetabling for LCMs isn't entirely in the Scottish Government's gift. The committee has encountered issues in relation to not being able to report on 6 LCMs since June. In 2 cases, standing orders were suspended as we were unable to consider provisions in an LCM. So what more can the Scottish Government do to allow sufficient time for consideration of LCMs by the Parliament and by committees, please?
I think that it's a difficult one to answer, Mr Kidd, other than to assure you that we're going to do everything we can to possibly avoid these situations. As I said to you earlier, particularly with supplementary LCMs, that's a consequence of more collaborative and constructive working with the UK Government, which I think we would all welcome. But I do hope to have meetings with UK Government ministers in short order, which this will be one of the topics. What can we do collectively to try and improve the situation? But again, as I said to Ros McCall on another topic, I don't think I've got a magic wand here that will address that. But we will, in our conversations with UK ministers, we'll reiterate the views of the DPLR committee as they've been expressed today.
Okay, well, that's fair enough. But let's narrow things down slightly here. More generally, can the Minister and the team update this committee on the latest position on upcoming LCMs, in particular any that are likely to engage the remit of the committee between now and the end of the session? Is that possible to do?
I'll pass to Claire, who's the expert in this.
Thanks. So there are a number of bills that we are aware of that are still to come through this first session of the UK Parliament from the King's Speech. So there is an LCM expected on the Public Office Accountability Bill, formerly known as Duty of Candour, Cyber Security and Resilience Bill, Northern Ireland Legacy No. 2 Bill, National Wealth Fund Bill, Railways Bill, Elections and Democracy Bill, Armed Forces Bill, UK Energy Independence Bill, and an Artificial Intelligence Bill. We're also expecting legislation in the space of EU reset, pending the outcome of the EU-UK negotiations, and a major sporting events bill.
Good. Well, at least you were well prepared for the question anyway. So, no, but thank you very much. That's very considerable, actually, isn't it? You know, and a lot of those are going to be substantial bills, obviously. So my presumption is that a number of those will head into next Parliament, never mind anything else, because that won't all happen within the next few months, will it?
A number of them are expected to be introduced in the next couple of months, but we don't have the same level of detail on a lot of them, and that's exactly, as alluded to in my answer to an earlier question, the issue we're pressing with counterparts at Westminster about the timing of the election and understanding when is the consent process going to be engaged.
Yeah. And that's particularly the case around the EU element of this, right. To understand the timings in the context of the pre-election period and into the next Parliament. I would like to think, I'd like to be assured that there are good conversations between my officials and your clerks to keep the committee appraised. But if you feel that can be improved, then we're happy to take that away and look at it.
Okay, thank you very much. Okay, well, just to go off at a wee bit of the tangentials here, this committee published its report on the inquiry into the framework legislation and Henry VIII powers, it's a term which I absolutely hate, on the 24th of March 2025, and was debated in the Chamber on the 24th of April with the former Minister in that role. You'll be aware that the committee undertook an inquiry on framework legislation and Henry VIII powers, publishing our report in March. The committee has agreed since then that it will look at producing guidance which we hope might be helpful for not just Scottish Government, but also stakeholders and other parliamentarians and anybody with an interest in public policy. Would the Scottish Government wish to see and engage on this draft guidance and work with the committee in order to develop this and move it in that direction?
I think that would be quite a useful exercise. We'd be happy to engage with you if we could. We might spot things that you haven't spotted and perhaps be helpful. I think it would be useful to the Parliament to have that. So happy to commit us to work closely with the committee on that.
Well, that sounds very positive. Thank you very much. Thank you.
Okay, thank you. Can I just want to come in on one of the questions that Bill Kidd posed, and that's with regards to the LCMs. Just to recall at the end of the last parliamentary session, clearly different circumstances as compared to what we're going into now. Obviously, COVID was still very much alive there at that point. In addition to the parliamentary rules, which were altered, leaving MSPs still as an MSP up until the day before an election, which was unusual. And notwithstanding also that it's now a different government that's in power in Westminster. So over that, in terms of the planning for the period when this Parliament dissolves for the election, in addition to the timescales that the current UK government will be looking at bringing forward legislation and any potential LCMs, what would the impact be in terms of the scrutiny of Parliament? Because clearly there will be no Scottish Parliament for a period. So I'm just
committees for a period.
No committees, indeed. Yeah. So I'm just considering that element because obviously it's, as Ms Trail touched upon a moment ago with regards to obviously the timescales of bills coming forward and also the LCMs. Would there end up being that position, this Parliament being in a position of actually no scrutiny at all of some of the legislation at that early stage?
The premise of your question being that from the period of early April until potentially the end of May, there won't be committees.
Yes.
Yeah. I'm sure that's something the officials have been thinking about.
Yeah, our starting position in our conversations with our counterparts is that bills should be timetabled to avoid that scenario of a breach of the Sewell Convention by way of Westminster legislating without the Scottish Parliament being around to give consent. We have communicated the point, as the Minister alluded to, that there wouldn't be, we're not anticipating committees being operational until after the summer recess of 2026. Obviously, if there were an emergent situation that needed to be dealt with, there may well be an opportunity to do that through chamber business after the election. But our starting position is that committees won't be able to look at LCMs until September.
And again, that goes to the conversations that I would hope to have with UK ministers to reinforce that, on the back of which, again, I'll be happy to update the committee on where we've gotten to on that.
Good. No, that'd be helpful. Thank you. Okay, thank you. Colleagues, any further questions? Okay, no, thank you. Minister and your team, any final comments?
No, not at all. As I say, I look forward to working with the committee, and if there's anything, we've obviously committed to write back to you over a period of time on our various issues, but if there's anything that the committee feels that they want to further advise us on, happy to do that, and in particular looking at that piece of work that Mr Kidd had suggested.
Okay, okay, no, thank you very much. I'd like to thank you, Minister, and also your team for your evidence this morning, and it certainly has been very useful. So obviously we will, as a committee, we will have some further discussion later today with regards to the session. But certainly thank you very much, and that now concludes the public part of the meeting. Thank you. And I move the committee into private.